right. Good morning, everyone, and thank you for attending today. My name is Paul Gaines. I'm a shareholder here in the RMWBH San Antonio office. I am board certified in Property Owners Association law, and today we'll be discussing the 88th Texas legislative session and providing updates on the multiple bills that have been filed that, if passed, will affect POAs here in Texas. I'll be going through a lot of these pretty quickly because we have so much content, but if you have a question, there is a chat bar that you can enter the question in, and then our administrator will let me know. We can go ahead and answer those questions. And then we will also have a Q&A at the end for any questions that the audience might have. So let's go ahead and jump right in. So first, let's discuss some key dates for the 88th legislative session. November 8th, 2022, that was the general election for federal, state, and county officers. November 14th, 2022, bill filing opened for the 88th Texas legislative session. January 10th, 2023, the legislative session did convene at noon. March 10th, so about a month ago, this was the final day to file bills for the 88th legislative session. So that means that we're not going to see any new bills that are filed for this session. However, that does not mean that we won't see any revisions or amendments to the bills that have been currently filed. May 29th, 2023 will be the day that the session concludes. And then on June 18th, all passed bills that are not signed by the governor or vetoed will become law. So with the 2021 legislative session, we saw Senate Bill 1588. This was a huge bill. Multiple statutes were affected or created. It had a very large impact on our industry. Luckily, with this session, and after 2021, some of these bills being applied out in the real world, now we are seeing some corrections to some of these statutes from the 2021 legislative session. We'll go through a few of these quickly, but a lot of these are very good. It's very good to see some of these legislators working with us and trying to amend some of these statutes that really, whenever applied, were just impractical. So Senate Bill 1668, that's Hughes, and House Bill 3503, Turner, these are companion bills. Senate Bill 1668 was scheduled for a public hearing on April 19th, 23, so that is tomorrow. House Bill 3503 reported favorably as substituted on April 17th, 2023, so that was yesterday. So this would clarify many of the confusing aspects of Senate Bill 1588 and would apply to both condominiums and single-family associations subject to Chapter 209 of the Texas Property Code. For condominiums, these bills would add Section 82.1142 to the Texas Property Code and would essentially mirror the language under Chapter 209 that already applies to single-family associations. This would require condominiums at least 60 units or contracted with the management company to have documents on a publicly accessible website. And Section 82.116 would be amended to require management certificates to be filed with TREC. Again, this is something that's already required from the 2021 legislative session for single-family homeowner associations. And then Section 82.157 would be amended, capping the resale certificate fees at $375, just like single-family homeowner associations. Now, as many of us know, the 2021 legislative session brought about some pretty bad statutes, and one of them was the security measures statute. Just a lot of gray area in the language and how it was drafted. Luckily, with these bills, we're going to see some corrections to the perimeter security fencing issues. For example, 202.023C would be amended to allow the association to, 1, prohibit the placement of fencing that obstructs a sidewalk, drainage area, or easement, or license area. In my experience after 2021, there were a lot of issues of security fencing being placed in the front portion of a lot, and then a lot of encroaching on sidewalks, drainage areas, etc. Number 2, require a driveway gate to be set back a sufficient distance from the street to prevent a vehicle entering the gate from impeding a passing vehicle or pedestrian. With the installation of perimeter security fencing, we've seen a lot of safety issues. This is addressing one of them. The way that we already drafted our policies or recommended to clients would be to have that gate, if there was one on the front portion of the property, to swing inward to avoid any obstruction of pedestrians or oncoming vehicles. But luckily, if this bill passes, that would clarify the association's right to implement those rules. Unless otherwise provided by a dedicatory instrument, prohibit the installation of fencing in the front of the frontmost building line of a dwelling. So if this passes, this is a big win. This would essentially let the association regulate any of that security perimeter fencing in the front portion of the lot. And then also impose other regulations relating to the building or installation of security measures that the POA determines are necessary to prevent and minimize a hazard or risk to safety or health. Again, this is providing more discretion for an association to regulate these perimeter fences and security measures. And if passed, in my opinion, this would be a big win for associations in Texas. So with Senate Bill 1588, there were some new regulations concerning ACCs and then the people who could actually serve on ACCs. Section 209.00505C would be redesignated by these bills as 209.00506 and amended to state requiring a person wishing to serve on the ACC to timely notify the association in accordance with 209.00507. Not a big issue there. All you need is a notification of your desire to run for the ACC. Allow the association to appoint someone not currently eligible to serve on the ACC if all those people eligible under 209.00507 had been given positions and vacant positions remain. This would really clarify the issue that smaller associations have, where previously before the 2021 legislative session, you had board members who also served on the ACC. This was because typically in smaller associations, you have a lack of volunteers to hold these positions. Essentially what this bill would do is stating that if the ACC cannot be filled, if those positions remain vacant, then as a last resort, then board members, board member spouses, and then people residing in the home of a board member would be able to fill those ACC positions. And section 209.00507 will add notice requirements for the election or appointment of ACC members, and this language would essentially mirror the solicitation of candidates language under Chapter 209 of the Texas Property Code. Senate Bill 1363, trying to correct some of those issues that associations have had with front lot perimeter fencing. But in my opinion, this one just isn't going to work out in the real world. This is relating to enforcement by a POA of restricted covenant that prevents a property owner from building or installing certain security measures. This has been referred to the Business and Commerce Committee on March 16th, 2023. We haven't seen any action since then. And this would amend section 202.023C to allow a POA to adopt or enforce a restriction prohibiting the perimeter fencing in the front yard, but only if that restriction has been approved by 75% of owners. 75% supermajority, incredibly difficult to obtain. Even declaration amendments with 67% are, of course, easier to obtain than 75%. So in my opinion, this just would not be practical whenever it comes to restricting the front yard perimeter fencing. The 75%, again, it's very hard to get that kind of participation for community. It's very hard to hit that threshold of a vote. House Bill 3776. This is relating to the eligibility and solicitation of persons to serve on the ACC of a POA. This was referred to Business and Industry Committee on March 20th, 2023, and would mirror the language under Senate Bill 1668 and 3503 that we just discussed. So solicitation requirements, notice requirements for the ACC members, and then also the vacancy issue of ACC members being able to serve. And this would only apply to single-family associations in Texas. House Bill 1367, relating to the violation of certain laws and provisions of governing documents and the recall by property owners of a property owner association board member. So recall, This is essentially a bill that's addressing the removal of an elected board member. This was left pending in the committee on April 17, 2023, so we'll see if we see any movement on that. Would add sections 209.00595 and 209.018 to the Texas Property Code and would only apply to single-family homeowner associations. Some of the requirements under the bill would state that 20% of the voting owners would make a petition for the recall election. In other words, for the removal of a board member. The election must be held no later than 90 days after the association receives the petition, and then at the actual meeting, there would be a majority vote that would remove the board member. Now, many bylaws already address removal requirements. If this was to be approved and go into law, this would likely conflict with a lot of removal requirements that are already in association bylaws. So those provisions would probably have to be amended. In my opinion, the bylaws should just address the removal. We don't need it in statute. However, 1367, this would provide for a removal procedure that would have to be followed. And then also 209.018. In 2021, we saw a new statute with Senate Bill 1588 that addressed suing associations and board members for violations of 209 in JP court. It looks like the intent of this particular statute is the same. Owners could bring an action in JP court if a board member violates 209 of the dedicatory instruments, and then it provides some remedies for violation. For example, immediate removal of the board member from the board, financial penalty to the association for damages incurred by the owner resulting from the violation, and then allowing the owner to deduct the amounts awarded from future regular or special assessments. House Bill 1786, relating to notice to property owners of the adoption or amendment of certain restricted covenants. This was referred to the Business and Industry Committee on March 7th, 2023, and would add section 202.0045 and amend section 209.0042. Would apply to both condominiums and single-family associations in Texas. Essentially, this would state that POAs would not be able to enforce a newly adopted or amended restriction prior to the 60th day after notice is given to the property or unit owners. So that means even if you adopt an amendment or a new restriction, even though you file it pursuant to Chapter 202 of the Texas Property Code, it's not going to become effective until you provide the 60-day notice. Moreover, there are very strict notice requirements for this particular bill that would create not only an administrative burden for associations, but be very costly. For example, you would have to publish in the local newspaper notice of this adopted or amended restriction. You'd have to send it via certified mail to the owners. Just a lot of hoops to jump through, even after the homeowners are the ones who have likely voted to amend the declaration of the restriction. They've already had notice of it. So it would just go further with the requirements to actually make the adopted or amended restriction effective. House Bill 1799, relating to the authority of a POA to regulate the street parking of certain vehicles. This bill has a lot of red flags. Most restrictions in Texas, most restrictions that I've dealt with, have prohibitions against commercial vehicles. If this bill were adopted, many of those restrictions would become unenforceable. This bill provides that associations could not restrict street parking of government vehicles, vehicles used in the course of a resident's employment. What would that include? Commercial vehicles, maybe a flatbed, maybe some other type of trailer. Vehicles required by the resident's employer to be parked in the immediate vicinity of a dwelling. And this would apply to both single-family associations and condominiums in Texas. House Bill 614, relating to property and association fines. We have seen this theme throughout multiple past legislative sessions. In 2021, there were similar bills addressing property and association fines as well. Now we're seeing it again. So the status of this current bill, committee report sent to calendars on April 3rd, 2023. This would not give associations the ability to fine. It would only apply to associations that already have fining authority in their dedicatory instruments. If an association does already have fining authority, this would require the association to adopt a deed restriction enforcement and fine policy that, one, addresses all fine types. So, for example, trash cans, lawns, failure to construct improvements in accordance with ACC plans. You would have to list those specific requirements and fines in this policy. You'd have to have a schedule of fines, and then there's also filing and posting requirements. One that would create, again, a very large administrative burden and be costly to the association, which would be sending a copy of this particular policy to all homeowners on an annual basis. This would only apply to single-family homeowners associations. House Bill 330. This is relating to the regulation of residential wind power facilities by property owners associations. Under Chapter 202 of the Texas Property Code, we already have statutes that address rain barrels, solar energy devices, xeriscaping, etc. So this bill essentially would introduce a new type of power, which would be wind power facilities. This was referred to Business and Industry Committee on February 23rd of 2023. We haven't seen any movement since then, which is a good thing. Residents would be able to install a wind power facility of, quote unquote, appropriate residential scale. Now, here's the issue with this particular statute is that it is or proposes to be a one size fits all. So appropriate residential scale. What does that mean? Is that based on the size of the home? Is that based on the size of the yard? Whenever it comes to these wind power facilities, what exactly does that entail? So there's a lot of gray area, a lot of issues with this particular statute. It would apply to both single family and condominiums if passed, but would have an exception for declarants, stating that declarants during the development period could prohibit these particular items during the development period, very similar to solar energy devices under Chapter 202 of the Texas Property Code. Senate Bill 468. This is relating to the authority of a POA to regulate the assembly, association, and speech of property owners or residents. This was authorized on March 14th, 2023. It would add section 202.013 to the Texas Property Code and apply to both single-family and condominium associations in Texas. Under the bill, associations could not restrict a property owner or resident from, one, peacefully assembling or meeting with POA residents, members, or their invitees or guests in common areas. Two, inviting guest speakers, including public officials and political candidates, without the prior approval of the association to meet with POA residents, members, or their invitees. And then three, there are some exceptions that seem to mirror the language under the religious items display statute, which is you wouldn't be able to hold these if it threatens public health or safety, violates a law, or contains offensive language or graphics. Unfortunately, this bill would open up a lot of issues for associations. It takes away the control of the common area from the association. For single-family homeowners associations, this is typically property that's owned by the association. What this bill is saying is that without prior approval, members and their guests and speakers can essentially set up an event to be held on these common areas. There's many issues that can come about with that. What if there is already some event scheduled for that particular common area? Any other conflict that would happen with that common area. We see a lot of issues that might arise with neighbors concerning some of these political rallies or other events that would be held without HOA approval. So yes, Senate Bill 468 creates a lot of issues for associations. House Bill 3775. This is similar to the previous bill we discussed, relating to the authority of POAs to regulate the assembly, association, and speech of property owners or residents related to government officials or candidates for political office. Essentially, this would only focus on political candidates coming to common areas to speak. So only political candidates qualified in an appropriate election. And the POA would be able to enforce the gathering by abiding by the same rules you already have from a common area, such as fees, deposits, occupancy, etc. So although this bill has a few issues, it does give the board and the association more discretion, at least to control these events if they are to occur. And because it would add section 202.013 to the Texas Property Code, it would apply to both condominiums and single-family homeowner associations in Texas. House Bill 886. This is relating to requirements to file a property owners association assessment lien. This has been left pending in committee on April 17, 2023. Let's hope we don't see any movement on it because this prolongs the collection process by about 9 months. So currently, we already have notice requirements under Chapter 209 of the Texas Property Code. Typically, if there's going to be a collection process, there's courtesy notices that are sent. Other notices, if the association's contracted with the management company, and then the ultimate 209 notice under Chapter 209 of the Texas Property Code that provides for a 45-day notice. What this would require is 3 additional notice requirements, as well as a 180-day waiting period prior to any lien filing. As I stated before, we're looking at another 9 months added to the collection process. That means if somebody fails to pay their assessments, association would not be able to really try to collect for almost a year. And who's picking up the slack during the time that those assessments and other charges remain delinquent? Well, it's the other neighbors in the community who are paying the assessments. So yes, let's hope that this one doesn't pass. This is a bad one for associations and would only apply to single-family homeowner associations in Texas. House Bill 1252, this is relating to audits by single-family homeowner associations. Under Chapter 82 of the Texas Property Code, which already applies to condominiums, there is a statute that addresses the requirement of an annual audit of the association records. This would be mirroring that language under Chapter 209 and applying it to single-family homeowner associations. So this bill would require single-family POAs to conduct an annual audit of financials. The status is this has been referred to the Business and Industry Committee on March 3rd, 2023. We haven't seen any movement since. House Bill 1193. This is relating to prohibiting housing discrimination by a POA against a residential tenant based on the tenant's method of payment. The committee's report has been sent to the local and consent calendar on April 17th, 2023. And this bill would not allow POAs to restrict Section 8 housing vouchers. A lot of this has come from the rising rental market. We're seeing a lot more rental homes in subdivisions and other communities. And then also there's been some actions taken in Texas regarding some of these Section 8 housing vouchers. So we've seen, a lot of these issues already arise in Texas, and this bill is likely a result of a lot of those issues. If this passed, this would apply to both single-family and condominium associations. House Bill 378, relating to the authority of certain entities and individuals to prevent individuals from accessing private property for the purpose of registering voters or communicating political messages. We've seen this bill before in past sessions. Currently, the status, this one has been referred to Elections Committee, February 23rd, 2023. This bill would state that associations cannot restrict individuals from approaching a residential unit for purposes of voter registration or disseminating support or opposition to political candidate, party, or a measure. We've seen a lot of issues with this bill in the past, and we've addressed this as well. What if you're a gated community? What if you have a security guard? Would you have to allow access to these individuals to come to the community? How exactly would that procedure work? Moreover, a lot of people could claim that this is what they're doing, but really they're trying to sell the homeowner something. In my opinion, this just gives access to individuals to a private community that's likely not necessary. But yes, there's a lot of issues that arise, and a lot of the language in this bill is similar to the past bills that we've seen in other sessions. House Bill 3423 and Senate Bill 1767, This is relating to organization of, meetings of, and voting by condo associations and POAs. If passed, this would be a big win for associations in Texas. I know that a lot of the bills that I've discussed today, some of them don't look so good, but this one right here, this would clarify a lot of issues that condo associations and homeowner associations would have or have had since definitely the start of COVID and then the use of virtual meetings throughout Texas. So this was left pending in committee on April 17th, 2023, and then Senate Bill 1767 was referred to Business and Commerce Committee on March 20th, 2023. So Chapter 82 of the Texas Property Code, which applies to condominiums in Texas, would be amended to allow for 1, virtual meetings, and 2, electronic voting, regardless of what the bylaws state. This is fantastic because 82 is a little confusing whenever it comes to those requirements. A lot of condominium declarations are outdated and may not address virtual meetings or electronic voting. So the fact that statute would actually provide that both of these electronic voting and virtual meetings would be allowed would be a big win for condominium associations in Texas. And then section 209.00592 of the Texas Property Code, which would apply to single family homeowner associations, would be amended to allow electronic ballot as a recognized voting method. So as we all know, with COVID-19 and stay-at-home orders, a lot of virtual meetings were utilized. And after all of that stopped and people were allowed to go back out to work, people realized the benefit of having these virtual meetings. And it's really stuck in the association industry. In my experience, it's been a great tool for associations because it's less costly, especially if you have to have a guest speaker at an annual meeting. It's more feasible for people to vote electronically and then also attend a meeting from their home. And then also a lot of times if there's going to be a disorderly meeting, if it's done virtually, things go much smoother and business is actually completed. So in my opinion, this is a fantastic bill. And right now, like I said, the status is left pending in committee and then referred to the Business and Commerce Committee, and if passed, would apply to both condominiums and single-family homeowner associations in Texas. House Bill 3064, relating to the right of a property owners association member to speak, an association or board member, referred to Business and Industry Committee on March 14th, 2023. This would add section 209.00511, requiring a homeowner forum for every association meeting. So that's member meetings as well as board meetings. The association would still be able to restrict time and manner in which the member is able to speak, and this would apply only to single-family homeowners associations. And then lastly, we have everybody's favorite bills, and those are the chicken bills and maybe the rabbits as well. Last session, we saw a lot of the chicken bills. A lot of them were filed because of the big Texas freezes that we had, a lot of power outages, a lot of people wanting to be self-sufficient, especially with food sources after having COVID-19. So we saw it last legislative session. We didn't see anything pass. But this legislative session, there are a lot of bills that have been filed addressing these matters. For example, House Bill 276, House Bill 92, which is the big one, Senate Bill 326, and House Bill 1191. These bills generally address the following: raising 6 or fewer fowl or rabbits, growing fruits and vegetables, installing solar, rain barrels, rain harvesting systems, and generators. This is already addressed by Chapter 202 of the Texas Property Code, and then cottage food production. All of these bills only apply to single-family homeowner associations. So we actually just discussing this bill a few minutes before we actually started this presentation. The current status of House Bill 92, which is what we refer to as the chicken bill, passed the House on April 17th, 2023. So that was yesterday. Most of the public comments that we've seen regarding this bill have been positive, but of course there are many ramifications if this bill is passed. Unfortunately, the way that the bill is drafted would be a one-size-fits-all. It if you were to have 6 chickens, 6 rabbits on one lot, you have small lots in community, there's 100 lots and everybody has these animals on their lots, that creates many issues. Property values might go down. You might have health issues with, the spread of diseases. You might have neighbor issues with people not maintaining the animals in the backyard. There's a lack of details on restrictions the POAs can pass. Again, health and safety issues. There is a max combination of 8 rabbits and 8 chickens. And then property value issues and the increased wildlife activity due to placement of vegetables. So unfortunately, the way that's drafted, again, we don't have certain acreage requirements. And with many of the new developments that are being constructed, there's very small lots and very small backyards that, in my opinion, cannot sustain this amount of animals. But currently, just to give everybody an update, this has passed the House, and we'll be providing more updates down the line regarding this particular bill.